Well, back when they asked us to do the first show, back 11 years ago, we said that we would do the show as long as you don't edit our faith. And they came back and said, "Well, it's your show; you can share it." And so they've given us the ability to really use the show to include a lot of Bible principles that we live by. And really, that's the foundation for our lives. And that's what we want to encourage people is that Bible principles work. And as each family turns their heart towards God, that they can set their family on a firm foundation.
Hi, besties. All right, you friends. Josh Duggar's rambling 60-page document basically going after the government, Joe Biden, the ex-former President Joseph Biden, declaring that multiple federal agents committed perjury, accusing the government of misusing evidence, and going after Bobby Holt, and all of these different blame games, and not being allowed to call witnesses. This document that he filed as a motion to vacate, well, the U.S. attorneys have fired back, and well, they're arguing right now with the court about whether or not his motion was filed in a timely fashion, but they've requested that they strike the document, which the court didn't strike. They're basically giving him a week extension. But I want to just share with you that he has clearly ticked off Dustin Roberts, who is the U.S. attorney that was one of the lead prosecutors in this case. He's the assistant United States attorney. He is in the Western District of Arkansas. He, along with two other U.S. attorneys, were the leads on this case. And Dustin specifically, his background is in prosecuting cases like this and dealing with cases that have a lot of forensic and digital needs. So computer fraud and CSAM type cases. He is an excellent district U.S. attorney. He did a wonderful job on this case. His entire team did an amazing job from start to finish. The way that they handled this with care and concern for the victims of this case and for the victims of his past, Josh's past, for his sisters. And they filed their response. They're seeking a request from the court to extend their response time. And the judge granted that they have another week to file a response, which doesn't necessarily address the issue at hand, which is this motion to strike. And what they're saying is that Josh erroneously sent a copy of this motion to vacate to the attorney's office in Arkansas. And what's weird is that the envelope arrived at the attorney's office without the stamps being canceled through. So it's unclear how this envelope ended up at the attorney's office, because when you send something through the mail, it gets scanned and then the stamps all get canceled out. And for some reason, this ended up without that. The postmark never went through. And they're kind of questioning that. And they're saying that it was sent to the wrong office. And then the clerk in this court ended up filing it as though it was properly mailed. So their argument is that they want them to strike the document that had been sent on the date of his deadline, which was, I think, June 24th. And they want it to be switched to this duplicate one that came in a month later. It's kind of confusing. I'll show you in a second. So they want them to strike the 179, which is a motion to vacate. And then they want them to identify document 182 that was filed as a duplicate copy as the correct one. Their procedural background reminds the court that he was charged in a 2-count indictment by a grand jury. And one was he was charged with receipt of CSAM in violation of 18 USC Code 2252A, A2, and count 2 charged with possession. And then on December 9th, after an 8-day jury trial, he was convicted on both counts. And then on May 25th, he appeared before the Honorable Timothy Brooks for sentencing. And then at sentencing, the court dismissed his possession conviction, which was count 2 of the indictment, on the basis that count 2 was a lesser included offense of the receipt conviction under count 1. The court proceeded to sentence Duggar to, among other things, 151 years or months in prison, to be followed by 20 years of supervised release. And with the 20 years of supervised release, there's a lot of stipulations. And within that supervised release, if he screws up at any time, he can have his release effectively revoked and he can go back to prison. So it's not as easy as he gets out in 151 months and then it's over. No, he's got another 20 years after that. And they say that he filed a timely notice of an appeal. And then on the appeal, they remind the court that he argued that the court violated his constitutional rights to present a complete defense by precluding him from calling and, if necessary, impeaching critical witnesses at trial. He also argued that this court erred by denying his motion to suppress statements after a federal agent physically stopped him from contacting his attorney and subsequently interrogated him outside of the presence of his counsel, and that this court erred by permitting the government expert to offer testimony on EXIF metadata and prohibiting his expert from testifying to the unreliability of the methodology used by the government's expert. The Eighth Circuit found that the court had unquestionably constitutional discretion to exclude the conviction under Federal Rule of Evidence 403. And as a result, the application of this well-established rule could not have violated his Fifth or Sixth Amendment rights. And that's to a complete defense. And his second argument, they found that the admission of his incriminating statements did not violate his Miranda. And as to Duggar's third argument, the Eighth Circuit determined that this court did not abuse its discretion in admitting expert testimony by the government's forensic analyst by metadata from Duggar's cell phone. And this court did not abuse its discretion by limiting testimony of Duggar's expert. So what Josh is now trying to do is he tried to get it so that James Futrell, the forensic expert for the federal court, he was allowed to testify about how they knew that this was him and how they were properly able to track everything so that they knew that it was Josh that had uploaded that he was the one that was viewing it, that it could be nobody else, right? And that now Josh's new argument is basically that James perjured himself and lied under oath. So when he couldn't get them to not allow him to testify and they wanted him to be thrown out, now they're saying, well, he just perjured himself. And so when it comes to the constitutional right with Randall Berry and with Caleb Williams, which are part of his motion to vacate, they said that the circuit court already ruled on this and they found that nothing had been violated. And then when it comes to the statements that he made, so Mr. Duggar is in his motion to vacate claiming that the HSI agent perjured himself and called statements that Josh Duggar had made, where he asked if anyone on the lot had been viewing CSAM or downloading CSAM. That wasn't recorded. And he's fixating on that because he's saying, well, it wasn't recorded, so it's just hearsay. But two agents heard him say it. So two witnesses heard him say that, right? And in the 30-minute Miranda interview where he waived his right to an attorney and he answered questions outside of his counsel, he asked a lot of questions and he made statements like, I'm not going to say I'm not guilty, or I'm not going to deny my guilt or deny guilt. I just don't know what to say. He asked about uploading or downloading numerous times, trying to get and figure out what his charges were. It was clear he knew why they were there. And that interview, the jury listened to while they were deliberating. And they didn't really care so much about his question that wasn't recorded. There was enough on that Miranda interview with when they met with him about the search warrant, there was enough on that interview that incriminated Josh. And it says, after the Eighth Circuit affirmed the judgment of the court, he petitioned for a writ of relief from the Supreme Court, which was denied. And that was denied on June 24th of 2024. And then on May 27th, he filed a pro se motion requesting appointment of counsel. The court denied the motion. And then on July 29th, the clerk of the court filed document 179, which was styled as motion to vacate under 28 USC 2255. The last page of document 179 is per standard practice, a scanned copy of the envelope from which the document was received by the clerk's office. The envelope is clearly addressed to the United States Attorney's Office and stamped received WDAR July 29th, U.S. Clerk's Office. Based on this filing, the court ordered the United States to respond to Duggar's motion by September 4th. And then on August 22nd, a document styled as a duplicate motion to vacate under 28, same thing, was filed on record. The last page of this is likewise a scanned copy of the envelope in which the document was received by the clerk's office. This envelope is postmarked by the U.S. Postal Service August 8th and was mailed from Dallas, Texas. This envelope is also labeled with a U.S. mail tracking code. As noticed by the clerk in the styling of the docket entry, the contents of the document 182 are exactly the same as 179, but for the intended recipient listed on the outer envelope. So he sent the first envelope to the attorney's office and the second one to the clerk of the court. As noted above, the document, the original, was filed by the clerk of the court on the 29th of July. However, what went unnoticed until recently highlighted by the filing of document 182 is that document 179 was not addressed nor directed to the court clerk of the court. Instead, the envelope was addressed to the U.S. Attorney's Office at 35 East Mountain Street in Fayetteville. And such document 179 was in fact legal mail addressed to the U.S. Attorney's Office and mistakenly opened and filed of record by the clerk's office. Legally, the fact that document 179 was mistakenly opened and filed is significant because it places a time limit on the filing of the 2255 motions. The limitation period runs from the date when the judgment of conviction became final. A judgment deemed final is on June 24th. So his time for relief would have ran out from June 24th, 24 to June 24th, 25. And the document 179, the mistakenly opened and filed version, was docketed on July 29th, over a month late, and as a result, his motion was not filed under timely. And then a legal aside, it says the envelope aside bears no proof that it was sent through the U.S. postal system. There is no postmark, and the stamps themselves are not canceled out. A clearer version obtained from the clerk's office is attached here too as Exhibit B. This is a stark contrast to the envelope in document 182, which contains a postmark tracking and canceled stamps. And they have a copy of these that they attached. And it is weird how this got into their system and how it got mailed with